Sir, no audio, sir.
Are you able to see the presentation and hear me now?
Yes, sir.
We can see
yes,
it.
sir.
You can see the presentation as well?
Yes, sir. Yes.
Yeah. My apologies for this. The technology has sort of let us down for the last 10 minutes. So jumping into the presentation, I will be covering the 4 topics today. As you see on this slide, I will be talking about the sale of counterfeit goods on the e-commerce portals, the data privacy and data theft, software and movie piracy in the digital world, and how the digital world is fueling the job scams that we see, and it shares some interesting cases of the real life situation on these scenarios. What as I mentioned, that the COVID has further expanded the digital footprint for everyone, and this kind of shows how the digital internet penetration in India is increasing, and I'm sure these figures were compiled before the the pre-COVID days. And probably we will end up 2020 on a very on a more healthier number than this, because of the dependence that people have on the internet in terms of buying their daily needs, whether it is medicines and anything else that you need to go leading a healthy and secure life without having a physical contact or lesser physical contact with people. Coming to the what is what the counterfeit issues in the digital world. The policy of the Indian government on the e-commerce side has been to promote marketplace model. So as opposed to what one would understand as a inventory-based model, and in the inventory-based model, one could sort of from the physical world take an example of let's say a shopper's stop, which probably is present in most of the cities of India. Even if they go online and send in the physical world and the digital world, they are inventory-based model, where they.
Excuse me. Sir, can you put the slides in presentation mode?
So the slides are still not visible?
Sir, it's visible, but it's not in slideshow mode, sir.
Is it okay now?
Yes, sir. Yes, sir.
Okay.
Thank you, sir.
Yes, now it is full screen. Yes.
No, it's full screen. Okay. So I was saying that the Indian government policy on the e-commerce portals has been to promote a marketplace model, which is akin to what you would see in a physical sense. You would see like a shopping mall, where Amazon, you can imagine running a shopping mall, and he tells all the people who want to come and open the shops or want to sell the goods that look, you are free to come and sell the goods and take the space from me. I will not charge you a rent, but I will charge a commission from you on whatever you sell. And that is, what has been the prevalent marketplace model as per the e-commerce policy. Unless you are, of course, and that was primarily because the government did not wanted the inventory-based model, because they thought that the bigger players, whether it is now the Indian player which we're looking at, the JioMart coming in, or the foreign companies such as Amazon or Flipkart, which was earlier an Indian company and is now owned by Walmart, that they have such deep pockets that they would drive the time grocery stores out of business by offering deep discounts. Now, when we say marketplace model, it brings into play. Before I sort of jump into that, let's just see why is the counterfeit goods so much easily available and sold on the internet. Obviously, one of the reasons is the anonymity of the internet. You could easily hide yourself by creating a. I think there was an earlier session on the domain name, and many people would have understood that when you are creating a domain name, there is a very minimal information that the registrar of the domain names asks you. As a result, you could create a website, where you could. There is no KYC requirement, so to say, like you have it with the bank or with any other institution. Even today, a company like a courier company like DHL or Blue Dart, if they have to deliver a packet to you, they even ask you for your KYC details and are required by the government as per the policy to carry out a KYC. But insofar as the domain name registration is concerned, there is no such rules. Therefore, you can hide your identity. You can actually buy a domain name as close as possible to the original domain name by adding few letters or words here and there, and hide your identity. Another reason for the counterfeit goods coming into India was the small packets, the courier companies which bring in these, that you can order anything online, and that could be a Chinese website or based out of Dubai or anywhere else in Asia where you find a good deal. Whether it is you never know. Sometimes intentionally you buy a counterfeit goods. Sometimes you may just get sort of persuaded by the looks of the goods, and they come into small packets through courier, and it is very difficult if you imagine these kind of traffic that comes through from each of these. Imagine the number of flights that come in and out of India, and there is a large amount of the load, as they call it, in terms of the courier agencies that bring in these goods from various places in Asia and in US and in the UK, and it is physically not possible for customs to actually scan through each of these packets, and they follow certain guidelines, but there are a number of such goods, counterfeit goods, that come into India through these routes. Now, there are these, we have heard of Flipkarts and the Amazon and, sometimes the Snapdeal or ShopClues. These are the big names in the e-commerce world that we know. They in all likelihood have some sort of due diligence policies on the sellers that they register. They must be asking, I believe, for their, KYC details. Because they have certain responsibilities in terms of the business they generate. But there are many small time e-commerce portals that are running in tier 2 and tier 3 cities, or people who are running inventory based model, and show themselves as e-commerce portals, and they bring in a large amount of they distribute and sell a large amount of counterfeit goods. In the luxury goods segments, which receive a lot of attention from the e-commerce portals, in terms of fake goods, is because of the higher margins. People do expect that these goods would be expensive, and as a result, many players are here who deal in the fake luxury goods. Recently, and we still don't have an e-commerce policy which the government wants to bring and change. We have also seen that a number of Chinese operators who simply to circumvent the law, had set up only an app-based platform. So they won't register in India. They won't create a company in India. They simply create an app through and allow the users to download those apps through either Google Play or App Store and order the goods. And there were a large quantity of goods, unless the government, in the recent times cracked down on them and have been cracking down for last year or so, sending goods by undervaluing them, declaring value not true to the value which is the cost to the customer, and sending it as gifts. So as you would know, there are certain value of gifts which a customer or an Indian citizen can bring in without paying the import duty. So there was an unfair, unbalanced situation insofar as the e-commerce sale of goods is concerned. And as a result of this, I haven't created a slide on that, but there is recently the government issued a notification, a separate set of guidelines under the Consumer Protection Act. At least the e-commerce policy is still pending consideration with the government relevant ministry. But the Ministry of Consumer Affairs did come out with the e-commerce guidelines under the Consumer Protection Act, whereby to protect the consumer, it is now required that anyone who wants to sell goods into India, they must have to register themselves locally. The guidelines also require that every e-commerce portal must have a return policy in case the customer complains that the goods supplied to him are counterfeit goods. They are also required to inform the brands in case the consumers complain that certain brand name, under the certain brand name, the counterfeit goods are being offered. These are some of the things which, there's a long list under the e-commerce rules which the government has come out with, and we will see how this pans out. In terms of the tension between the brand owners and the the e-commerce operator arises out of what is called as the intermediary liability. Now, the e-commerce portal, as per the definition under the Information Technology Act of who qualifies to be an intermediary, does include an online marketplace. So, which essentially mean that if I am an intermediary, I am not actually playing a role in sort of what is being sold on my platform, in the sense of that I only facilitate the transaction. I actually do not sell that goods in my name. So Amazon typically says, look, I'm an online marketplace. I offer space to various sellers to come and sell on my platform, for which I charge a certain amount of percentage of fees for them to sell, but I do not control what they sell. It is my duty as an intermediary to make sure that the platform is free from counterfeit goods, and therefore I carry out a certain amount of due diligence when I enroll them, but I cannot guarantee what they show in terms of a photograph. And most of the times what we have seen how the counterfeit goods are sold is that the seller would show a certain photograph which is generally taken from any of the image library, whether on the Google or many other image library free of cost which are available, and they take an image of the original product, pasted there in their on their page, and what gets sold may be entirely different. Now, the tension between the brand owners and the likes of Amazon's, or Flipkart's, is the issue about who takes the liability when the counterfeit good is sold on their platform. So we have to better understand this. Turn to Section 79 of the Information Technology Act, and here the government has provided, the Act has provided a certain amount of safe harbor, as we call them, to the intermediary liability, to the intermediaries, so that they are not held, liable for any wrongdoing done by someone who is actually done the act of counterfeiting in this case. So the basis of this all is that to say that, in a very sort of crude, rudimentary language would be that if Airtel job is to provide you an internet connection, but what you do with that internet connection, the Airtel should not be held liable for that. So, essentially, if you create that internet connection and therefore thereafter the user of the internet actually uses that internet connection to distribute pirated software or sell counterfeit goods, then why should Airtel be liable? And in the same way, because the definition of the intermediary, as I showed in my previous slides, include online marketplaces, they say that, look, we are not liable for ultimately what the seller is doing in this case. But the Act also says that the intermediary must observe due diligence and follow the other guidelines that have been prescribed under the Act. There is a big discussion on what kind of due diligence the intermediary is required to exercise. Does the due diligence end once he enrolls the seller, or does the duty to carry out due diligence continues even when he actually is completing a transaction with the customer? Now, the exception to the Section 79 of the Information Technology Act also says that the safe harbor or no liability of the intermediary ends if he in any manner conspires or aids or induce the commission of the unlawful act. In this case today we are talking about the unlawful act being the sale of the counterfeit goods, or on being notified by the brand owner, let's say in the counterfeit goods case, that is normally the case, that there is counterfeit goods being offered on your platform and you don't take enough action, then you don't take action to remove them. In fact, the government has also issued the Information Technology Intermediary Guidelines, which are also under revision at the moment, but the current guidelines provide that on being notified, a platform must remove within 36 hours any counterfeit goods being sold. Now, the problem or the difficulty for the judiciary, the difficulty for the the policy makers in the context of the intermediary comes from the fact that there are many kinds of intermediaries. There are intermediaries in the counterfeit goods context. Probably what we're talking about, from the point of view of, let's say, Facebook being an intermediary, maybe a little different than when we talk about Amazon as an intermediary. And why do I say so? I say so because the fact that when it comes to Facebook, for example, we are talking about someone commenting on, let's say, a certain government policy or commenting on a certain individual in the form of a debate, and during that discussion, if they are talking about me, and if I just find that offending and I want to send a notice to the Facebook and say that please remove all of that offending material, because Section 79(3), your liability as an ISP will get removed because I have notified you that, look, this kind of a conduct of yours is unbecoming of what is provided for under the the safe harbor provision. The very difficult for Facebook to decide that what is right and what is wrong here. It probably is easier in case of Amazon. If suppose, for example, a well-known brand, let's take Puma for shoes, if the Puma complains to the Amazon that's saying that, look, so-and-so entry of so-and-so seller who is offering those counterfeit goods should be removed because these are counterfeit goods, it may probably be easier for Amazon to take that step immediately and remove those goods. But I will come back to this Myspace judgment. But what I was going to show was, oh, the slide in there, sorry. There was a judgment of Supreme Court in the context of actually Section 66A, which was, which has been scrapped under the, which has been sort of nullified by the Supreme Court by a judgment called Shreya Singhal versus Union of India. In that context, the Section 79 or the safe harbor provision was also discussed. And the wording of being notified was held by the Supreme Court to say that you must get the order of the court in order for any ISP to remove the goods. And that actually came in the context of freedom to, freedom of speech and expression under Article 14. But in now, as I was saying that, the challenge in case of ISP liability comes because not all intermediaries are alike. An intermediary which is operating in the information side of things like the Facebook and the likes of even a Google search engine is very different from someone like Amazon, who's of purely commercial venture offering the goods. But if we were to strictly interpret the Supreme Court judgment, then they are actually not, even after being notified by the Puma example that I gave you, they may still not, may turn around and say that, look, I'm not removing the goods unless you get me the order of the court. And the practical difficulty that as a practicing lawyer that I have faced here is the fact that when you see a seller on a platform like Flipkart or Amazon, and you want to and for sure that the goods that he's selling are counterfeit, and if the platform turns around and say, I'm not removing it, go and get the court order, I am constrained because of the budgetary reasons. I'm constrained because the platform does not give me the complete address. So that means I will have to first order the goods, have them delivered. And if I have to spend money on every transaction like that, then it will become practically impossible for me to actually carry out enforcement campaign against everyone who is present online. And you can imagine hundreds and thousands of it being sold. Such goods being sold on different platforms and on different portals set up. Very quickly coming to the this very important case in the ISP space, which is the Myspace judgment, and here the court held that this was a case between the T-Series, which brought the action against Myspace, which used to be a popular, similar to what we have today is like, you could say that it was a music time of Instagram, what Instagram for the photographs is, it used to be for the music, the Myspace. It had at one point of time 1 billion, subscribers. It has lost its value, over the years because of various other, the way the music industry has changed. But anyway, this case kind of laid down that, the court came to the conclusion that intermediaries in this case can be held liable if they have the specific knowledge of the infringing content on the website, and the content owners has given them the notice or take down, and there is no need for the court order in these cases. So in this case, what had happened was that the T-Series did not wanted, the users or the subscribers of the Myspace to play the music library of the songs which were owned, for which the copyright was owned by the T-Series, and they complained that, look, there are subscribers who are uploading those songs, and the Myspace should be held liable for aiding and abetting in creating that infringing content. And the Myspace said, look, I am an ISP, therefore Section 79 safe harbor, I should be protected. The court, after much discussion and came to the conclusion that their role was actually not of aiding and abetting. It was an algorithm which was being used by them without actually playing any critical role. And as and when the T-Series brought it to their attention, they took steps to remove such infringing content. After the Myspace, there was an interesting case in the Delhi High Court concerning the counterfeit goods being sold at a website, Shop Clues. I'm not sure if Shop Clues is actually running today as a portal, because there was, I think they lost a lot of money in some stage and they were not that popular. There was Skull Candy, which sells the the headphones and various other accessories that go with the mobile phones. Primarily the headphones. They were being sold counterfeit, and in this case, the single judge of the Delhi High Court, while examining the procedure followed by the e-commerce portals, came to the conclusion that it actually looked at how the transaction was carried out. And if you look at the transaction, taking Amazon only as an example, you would see that they collect the money. They actually probably have a warehouse somewhere in which they have stored the goods, and they deliver to you if you are a Prime subscriber within the 24 hours of delivery, or sometimes 36 hours of the delivery. And when the judge looked at the transaction in detail, it was a lady judge, and she came to the conclusion that it seems to me that the intermediary here, in this case Shop Clues, is playing more than the role of just a ISP or just an intermediary to act as a facilitator between the buyer and the seller, and therefore it held that the safe harbor was not available to this intermediary in this case. The matter went into an appeal to the two judges bench, the division bench, and they have stayed the order, and there is yet this position of Myspace is still in place, and what will happen in future is yet to be further debated. I also wanted to share this interesting observation of the court. It is still not a decided case in the stricter sense of it. This is what the court held in case of an intermediary order that it granted. In this case, it was actually a job, sort of portal, and there were. This case was brought by Reliance, saying that, look, in their name of the geo, this particular portal is posting a lot of jobs, and most of them are actually fake entries, and people are getting confused. And we are getting a lot of calls, we are getting a lot of queries, and our name is being spoiled in the bargain. And the defendant took in the portal took the defense that, look, I'm thinking the same as I mentioned to you in the Myspace case, that, look, I don't create anything. I have an algorithm and I run that algorithm, and the jobs get posted automatically. And as and when somebody lodges a complaint, I pull down the URL. And a very strong comment came from the court at the intermediary stage, although the matter is still sub judice, and we will see how it gets resolved. But the judge said that, look, you are running the portal not for charity, but for making the money. And, in case, it requires a policy change from you, that is your problem. But you got to safeguard the customer. You got to carry out due diligence if you really want to be exempted from any action and take the refuge under the safe harbor provisions of Section 79. So that was what I wanted to talk about in the context of the counterfeit goods. I'm moving to my second section, which is the movies and software piracy. In the early days, we have seen, not many years, about 10 years back, we saw, from the movies started coming on the, compact discs, and there was, way before that, there were cassette deck. And essentially from, the cassettes to the floppy disks to the CDs, all of this saw people, finding a way to copy the data very easily, and therefore, in the digital space, I mean, in more in the physical sense of it, the movie piracy and the software piracy proliferated in that era. But then a big leap came when things stopped being in the physical. People stopped storing anything in the physical form. Even today, the USBs have gone out of fashion because you have you can create you can take space online in the likes of the Google Drive is there. There is many other similar online sort of space to be provided where you can store all your big data files, and these spaces are free for you to store your stuff in the cloud. And that's brought a big change in how the movies and software piracy today is happening. We have seen, even before any movie is released or it is about to be released. Early days when I used to work for the internet piracy, we would actually target the physical confiscation of the movie CDs, or we will go to the software markets and seize the the Microsoft Word CDs and many other. Probably they still get sold, but most of the time everything is now stored in the cloud. And in terms of movie, there are various big popular sites which have the torrent of various URLs being provided, and you can stitch them together and actually play the movie. People like the Pirate Bay, and some of the other sites where you can download any movie without having to pay for it, are quite popular in the Indian context. And it is estimated that we lose almost, the government loses almost 2.8 billion of the entertainment industry loss, and I'm sure as a result a high amount of taxes also get lost. We have seen various popular movies which are leaked online even before their release dates, and in all of these now it has become very common for the the distributors of the movie or the producer of the movies in many cases to actually come to the court and obtain what are called as the John Doe orders. A John Doe order, which in India we've now called them Ashok Kumar orders. Essentially, Ashok Kumar in the courts is just a name given to a person whose identity we do not know. So you would, typically go to the court and say, look, I have identified these 5 websites and I am joining a defendant whom I am nicknamed as Ashok Kumar, because the moment, it's like the game of whack-a-mole, you stop one website, it will get replicated at somewhere else. So that is what the Ashok Kumar or the John Doe order is about, where you get an open order and say to the court that as and when I find new websites, I will be allowed to join them in place of Ashok Kumar, those specific defendants, and get and get the same order as you have passed against the websites or the defendants that I have currently identified. The question in some of these cases has also been that sometimes there are websites which are hosting only a very small amount of infringing content, and some of these websites are hosting more of the pirated content, and how should the court deal with those issues. So there is this case that I wanted to share, which is also incidentally decided by the Delhi High Court, where the concept of dynamic injunction came into play, and where the judge, where the plaintiff in this case, the UTV software, pleaded that why do I need to come back to the court every time I find a new, defendant? The process should be more simplified so that I don't have to move a fresh application to join every new defendant, and I should be granted what is called as a concept of dynamic injunction, which was borrowed from the Singapore jurisprudence, where these dynamic injunctions are commonly granted against websites which are engaging in online piracy. So in this case, the court framed certain issues, and some of the important issues framed by the courts were something like whether first issue was whether an infringer of a copyright on the internet is to be treated differently from an infringer in the physical world. And the court's observation, which I've just put on the website here, on my slides here, is important one. And the court noted that that nobody, these piracy websites are no longer about ideological reasons. So, there was a time when there were certain, sort of developers who would say that, look, I want everything to be free. I have, free software, free source. And therefore, the judge's comment here was actually more from that context to say that the piracy websites are not about ideological reasons, but they're making money. And it specifically quoted about Pirate Bay, where they were making $3 million a year, and there were others who were making more than $16 million in advertising. And therefore, the judge said that in such cases, why should we treat the infringer in the physical world different from the infringer who is operating in the, or a pirater who is operating in the e-world? Also, as I mentioned before, the Bombay High Court in particular has taken the view, and there are different courts like Delhi and Chennai have been more liberal towards saying that if you find someone distributing pirated material in the form of movies, software, or music, then close down the entire website. The Bombay High Court had taken the view that don't close the entire website, but only remove the specific URLs which are placed on that particular website. So court in this case decided to define what is a rogue website, and it said that, look, in some sense it is the question of the quantity, and if you see that there is a large amount of pirated, or the pirated business is their main business, while they also have other kind of contents as well, because most of the time these pirators are very clever. They place certain other contents on their portals than just placing the URLs for the pirated contents to be downloaded, so it said that the quantity which probably should dictate, and in such cases, and kind of in the advertising, how it is being advertised, the various advertisements are placed, should be taken into account to determine whether it is a rogue website. So as I mentioned, it is the qualitative or a quantitative one. In this case, it preferred a qualitative approach, and rather than saying, look, that if in case if it is not taken as a qualitative approach, then people who have small content will get away with it, and therefore if you are knowingly distributing a pirated content, irrespective of whether you are distributing one movie or two movies, the entire website should be shut down. And I was mentioning about the dynamic injunction. The court noted that in the digital world, it is so easy for someone to today create a website, and as soon as it is closed, it multiplies, and it can actually be created in less than a few hours, and the same content can be moved to another domain name. It can further be moved, and 5 more places it can be created the same content, because somewhere the files are saved in the cloud or in a physical sort of environment, and you can actually copy those files from the disks very easily, and therefore distribute it. So therefore the concept of dynamic injunction was put in place to simplify that you don't have to come to the court every time you see the what you call as the another website being created. And so there is always a flip side to the digital world. Now, I was seeing during the COVID time, there are a few players, including Google, which have started to offer businesses free website being created. They have written down algorithms on, by us telling people that, look, you don't have to do anything and we can create a website for you. And I think the domain used is business.site. So you can have rna-ip.business.site created by them free of cost. You don't have to even design it; they will design it and do everything. And interestingly, what we have seen is that we do a lot of work on the software piracy on the cloud, and we've seen that many of the pirators who we have shut down the websites by obtaining court orders, these websites actually are now moving towards these free services as well, because they don't have to pay. And so long as they can keep themselves up and running, their revenue streams keep coming up, because there are enough consumers who are willing, are wanting to get those software at less than 1/3 the price of what the original software would be, or even you can say even 1/10 the price of that. So they and these services, which probably were designed keeping in mind the entrepreneurs and small businesses, are being exploited by the pirators and the infringers in the digital world. Keeping the time in mind, moving to the third section of my presentation, which is the data privacy and data theft, which is obviously more sort of touches each one of us today. Everyone is sort of concerned about how do I keep my data safe. Obviously, we all leave data footprint, in various things that we do, whether it is, we go on a social media, and post anything on these websites like Facebook, Instagram, LinkedIn, etc. When we buy the e-commerce goods, we, from the portals like Amazon, Flipkarts, we give our addresses, we leave our, credit card details or any other wallet details. When we carry out financial transactions, and make payments through these e-wallets like Paytm, Google Play, Amazon, they all store a huge amount of data. There's a joke on the data theft that a particular pizza selling company, I don't want to name it, I think most people would know, and they were the first pioneers in delivering pizzas in India. And each one of us were very happy to provide them all our details or whatever they asked for. None of us realized that, look, how much of the data we are giving away. And I'm told that in the first year of their operation, or in the next few years of the first 5 years of their operation, they made more money by selling that data than by selling pizza. So here you go, that how important the data is. And as a lot of people have started to say, this data is the new oil, which seems kind of correct. At the same time, you must have also seen that many a times when you go online, you are if you even knowingly, unknowingly click on a particular news story or a particular advert that pops up, and if it is about any goods or services, then you suddenly see that every time you go, your browsing history has been captured by that particular site, and it is algorithms are written in the back, and you would see the advert of that particular product or service being shown to you more and more every time you visit it. And that is all because there is someone who is collecting the data without you realizing that how much data footprint are you leaving. So what is what can you do? At the moment, we have a data privacy. I mean, other than the Section 43A, which provides for in the Information Technology Act, Section 43A, I'm talking about, which there is a great deal of discussion that it's not, enough in the sense of it doesn't. It's a very general provision. It does say that, I mean, anybody who is asking for handling this sensitive personal data, it does requires him to follow certain security practices, and has defined what is sensitive personal data, but it's not a foolproof law, complete law. And there is a data protection bill which is still pending and is being under discussion with the parliament. And unless that law comes into the play, the data protection mechanism in India, I personally think is still quite weak. Many companies have started to take cue from what is considered as the gold standard in the data protection law, which is the GDPR, European law on the data protection. Many companies have started to seek permission of the consumers, or the anyone from whom they collect the personal data. But we still have a long way to go in terms of how the consumer data is being exploited by the various companies who collect on a daily basis our data, and how they make use of that data. So to give you an example, the new data protection bill would actually make it difficult for example, and it's purely an example. Let's say you are banking with HDFC or ICICI Bank, and if during the KYC provisions, you've given them certain data, it would oblige them not to give away that data even to their subsidiary company unless you are their customers. So ICICI cannot give that data bank cannot give data to the ICICI Prudential, which they may have a shareholding in that, unless that data is personally collected by them. But at this stage, there is absolutely no law, and we all know that, I mean, with all the good policies and with all the good intention that these institutions may have, they very freely share the data which is given by the consumers, because there is no distinct law. In fact, as many of you would have read, when the Aadhaar Bill was challenged, the primary challenge against the Aadhaar Bill was the fact that the data was collected to create the biometric database of all citizens only from the point of view of their identification. But when the government decided that it will use this data for various other activities, it was challenged, and for a certain purposes, the Supreme Court scrapped the government schemes and said that no, it is not for which the data was actually collected. So therefore, we do need the Personal Data Protection Bill, or the the act which to come into play, and which the bill is pending before the Parliament. So coming to the current regime, which is Section 43 of the of the Information Technology Act. It does provide that any person who is without the permission of the computer owner, or any person who is in charge of the computer system, if there is an unauthorized access, or if there is a virus, when you must have read during the COVID phase, there was a lot of people who allowed their employees to work from home, and there were obviously compromise on the security side of things, and as a result, the data was hacked or the systems were hacked, and there were many cases of ransomware. So in that case, Section 43 does come to the rescue of the companies, because it is an offense for someone who is not authorized to access the data and does access it. The data theft actually also has another dimension, which I mentioned here, the employer-employee relationship, that even where what we are seeing, is that many a times when the employee change jobs, knowingly and unknowingly, they also take away the data from their previous employer. And as per Section 43, even that is not permitted and is an actionable, is an offense in terms of data theft. In fact, many of the cases in US, the trade secrets protection, between the employer-employee relationship is so high bar that whenever they are recruiting someone at a position where they see that it is a competitor employee, that they're recruiting, they actually hire a lawyer who vets it, the entire process, and works with the company in that recruitment, so that tomorrow they are not accused of any sort of data theft. We have seen that happening in case of a person from Uber, in the space of the Google, in the space of the driverless cars. If I remember correctly, there was someone from Uber who moved into the Google and took away, worked on the same project, and there was immediately a case brought on the data theft side of things. This is where it provides for the punishment in case of the data theft under Section 43. There is also these various sections. I don't intend to read each one of them, but they talk about if you steal the data, if you even receive the stolen data, then also it can be a punishment. Even someone impersonating in the online space, and trying to, which we have seen happening in case of, the frauds that we have seen in the banking industry, very, very common. People impersonate, identity theft happening, posing as insurance company, posing as bank employees, and then taking away the data, and as a result creating the financial gains for them. I think you may have seen this, but I wanted to share this Jamtara, video with you guys.
नमस्कार मैडम, मैं बैंक से बोल रहा हूँ, बैंक मैनेजर।
हाँ बोलिए।
मैडम, आपका एटीएम कार्ड को ब्लॉक कर दिया गया है, क्या आप उसे चालू करना चाहेंगे या बंद रखना चाहेंगे?
What? ये कैसे हो सकता है?
चालू करने के लिए अभी आपका एटीएम कार्ड होना अनिवार्य है मैडम। क्या अभी आपका एटीएम कार्ड साथ में है?
जी रुकिए।
कितना हुआ? कितना केजी हुआ?
कुमार के साइड से बात कर रहा हूँ। क्या आपसे 2 मिनट बात हो सकती है? आपका बैंक का जो एटीएम कार्ड है ना, वो बंद कर दिया गया है। तो ब्लॉक कैसे हो गया ऐसे कार्ड मेरा? मैं ट्राई कर रहा हूँ। देखिए, आपको एक मैसेज आया, ओटीपी होगा, वो आप कंफर्म कराइए। हाँ आया, एक मिनट बताइए।
शुरुआत में जब फेमस हुआ ये क्राइम का, उसका जो सोर्स है वो जामताड़ा था, तो जामताड़ा साइबर क्राइम कैपिटल के रूप में फेमस हो गया। लगभग 5 से 6 साल पहले की बात है। अचानक जैसे ही स्मार्टफोन और इंटरनेट बैंकिंग इत्यादि का फैलाव हुआ, प्रसार हुआ, सम स्मार्ट पीपल हु हैपन टू बी बिलोंगिंग टू जामताड़ा, दे थॉट कि हम लोग इस तरह का भी क्राइम कर सकते हैं। रोजगार के साधन नहीं होने के कारण कुछ युवाएं बाहर जाते थे वहां।
So, I mean, this is a series on the Netflix. I'm sure some of you may have watched. And, this is not something which is, which each one of us has experienced. We continue to receive many offers from various sources of, freebies being offered, and we fell into that trap. And at times these are, related to your own bank accounts, and people knowingly, unknowingly do provide the information about their details and get defrauded in the process. There are cybercrime cells created by the government. They are trying to do whatever they can, but I think the industry has to come together. What is very interesting is in the entire scenario is that we see that there is no coordination between the companies as well. So the same person, once he contacts on behalf of an X bank or an X wallet, then after few frauds, when he sees that people have started to recognize him for that, or there are complaints against him, he would change the name of the bank and goes to the second one and create, impersonate himself from that bank official. Some of them are very sophisticated. They would even create, they would even send you links to open where the link would land up on a page which has a very similar feel and look of the bank or the particular financial institution that he's trying to entice you to believe that he's the that it is not a scam but a correct one. And all of this is happening because there is the agencies as well, the law enforcement agencies as well as the consumers today are not reached that sophistication level which these people who commit these crimes have reached. They are much ahead of the game, and I think the industry and the law enforcement authorities have to up their game. I was told, I live in Gurgaon, but there is in the national capital region, there is a place called Noida. If some people may know, there are racket of people who are running, and you can buy actually a KYC account, account which has the KYC compliance and everything in a reputed bank for a certain amount of money. And there are gangs of scamsters who operate using those bank accounts. Where they receive the money, and many a times people feel that oh, I know the bank account he's receiving the money, therefore I should be able to catch hold of him. But these guys have just created those bank accounts. Till such time they can collect the money, they'll run it and then just move it to another bank account. Last but not the least on this, I wanted to say that with all the good intention that the Prime Minister announced on the 15th of August that we're going to create a national health mission whereby everybody would be brought on the same portal, and imagine the amount of personal information that will pass through every hospital that you visit. While there is very good intention, today we feel that every time we go to the hospital, every time we go to see a private practicing doctor or in a private practice hospital, they ask us to carry out the same test which we have carried out earlier, because there is no portal and nobody believes each other, and there is some sort of a racket being run in terms of making money in that sense. And if there was one particular portal on which everything was available, and that is being created by the government, I was on a panel and I was told that in Finland actually there is something like that, but again, that is a European country. They have a very strong personal data protection laws, and we are missing on those ones. So I think there's a strong need that if we have to create data is an IP, and if we have to protect data of every citizen in this country, then we make strong personal data protection laws. Now moving on to the last topic of my presentation, I will try and wrap it up in 15 minutes so that we have time for the questions as well. What we're seeing in the another phenomenon that we are seeing, and IP comes into the play because for creating fake websites, obviously these fake websites will have domain names which are very similar to the original domain names. The name of the companies are used, their brand names are used in order to lure the job seekers. Sometimes even the recent what we have seen, I was working with a company where they were quite disturbed by the fact that they started to receive so many calls from people because there was someone which created a website whereby he was the same name and just added a few words next to the domain name of the original well-known consumer goods company, and started to seek money from various 2-tier and 3-tier cities saying that I will appoint you as my distributor. And he had a very sophisticated process. He would accept the application forms had the name of the company written on that, which is a registered brand name. There was phone calls, there was a website, everything was there. And when we started to work on it, what we found was that the domain name had a completely fake address. I'm sure in the earlier presentation, it would have been shared with you that because how the flip side of the data protection is this as well, that as per the European Data Protection Act, the domain registrars are no longer required to display the complete details of the registrant of a particular domain name. So they have to they can mask this information. Nowadays, every domain registrar masks the information. So we were not able to get who is the actual person behind it. We have to first go to the court. We have to, get a court order in order to get that information. So this is again because of the, digital, because everything is moving on the digital side. More and more companies are, finding that they are hit by job scam. And this was one such company which, we had helped. The Hard Rock, which run cafes, they also run hotels in some places. And someone set up a website with the Hard Rock, name in Canada. I think it was called hardrockcanada.com and or hotelcanada.com, and started to place the job adverts on portals like Naukri, Shine, various other well-known portals. And to create the facade, there was a website, which people could access to. There was, he was sending out forms for people to fill in the details, and the forms had a printed name of the Hard Rock Canada with the logo and all the branding as originally the company would do. And he would purposely advertise the jobs which were for plumbers, electricians, and people who may not do so deep dive into it and will get impressed by the fact that yes, there is a website and there is a someone who answers the call. When the investigation was carried out into this scam, what we found was that someone who is the call used to come from Bangalore. The money used to be collected in accounts which were, or in fact, money used to be collected in an account for which the KYC was done in Guwahati in Assam. The bank account was opened in the name of an old lady who did not know anything. After the account was opened, the ATM card of that was taken away by the person who was somewhere in Delhi. He would withdraw all the cash the moment it went into it. So again, because of the digital world, the company was able to put together this, but in the end, we had to make use of the police and the courts and we still could not reach to the person who was on, who was actually running the scam, because the moment he saw more heat coming to him, he disappeared and closed down everything. So that is how, this is the challenge that you see in the digital world. Sorry, I did have. So this kind of, agreements used to be sent, you can see the letter of employment coming to people in the name of Hard Rock Hotel. And, a very proper job being done in every respect. And this is something which I have worked with so many companies and so many Indian well-known, established companies. Most of them are facing this issue, and that their IP is being exploited in the digital world to defraud people in the name of offering jobs and offering jobs. And it is getting more and more because the COVID. People are not able to go for physical interviews, and even the the well-meaning companies are actually interviewing everyone through these platforms like Google Meet or through the Zoom, WebEx, etc. That the people who are looking for a job feel that, this could be correct way of, going about it. And, as I mentioned, in this case, we filed a criminal complaint with the cyber cell under section 66D, as well as the, IPC. The other case was, that was filed by another hotel chain, Ritz, where again someone set up this website, as you would see, ritzparis007.com. He was again using the complete letterheads, everything, to defraud. And there are various, reasons for which they actually asks for money. Sometimes in the name of, if the overseas job is there, then there will be money being asked to process the visa. Sometimes in the name of, having a medical done, and then, they would say the medical is of a certain nature that it requires, 25,000 rupees to be paid by you. And, at that stage, the person who's thinking and already imagining him to be in Paris, he probably pays for it very easily. So these kind of letters sent out, all very official, you can see, signed by someone, even a stamp being used of the Ritz Paris. In this case, the company filed a civil suit and had the website shut down, and and that was probably the most quickest way for them to take this action. In many cases, you can also do the domain complaint as well, but then the risk that you always run is that, in case of domain complaint, is that it will take only, a few hours for him to remove, for example, 10 from here and create a ritzparis07.com instead of 007.com. So I think that's kind of in, comes to the, I have more things that I could share, but, in the interest of time, and I would stop here. And my apologies that there were some technical errors and technical challenges in the beginning, but we finally were able to run the presentation. And I'm here to take, any comments, questions that anyone has. Thank you.
Thank you very much, sir, for your wonderful session. You have given great insights in the domain. Now, I would like to ask, appeal all the participants to, if they have some questions, they can ask them. This is a question answer session now. You can ask the question. You can write in the chat box.
Am I audible, sir?
Yes, sir, you are audible, sir.
Okay, sir. I have a query to Sir Ranjan Narula. Sir, suppose I received some data, some infringement data, or some, some fake or piracy data from somebody. I am an innocent person, so there will be some legal action will be taken against me or no?
So I'm not sure what kind of data are you saying. I mean, if there is an IP in that data, then of course, let me put it this way. For example, giving you a very practical example, anybody who comes to our office who's working with us, like you see in the, whenever any movies played, there is a notification that comes in there to say that, copying of any content part or, complete movie is a offense under Copyright Act, and, there are sections coded. If the information that you have received is a confidential information, if there is an, intellectual property of someone else, if it is something which is valuable, and you have received it illegally, then yes, in even receiving that, you could be held liable.
So if I am not aware of that, if I am an innocent person, in that case, what will happen? That's my question.
So for example, I mean, because, it has to be very specific, probably, to be able to answer your exact question in what domain, but I'm just trying to imagine things here. So in case of software, for example, use, even if you are not aware, but you have received it from someone else, a pirated software, but if it is found on your computer, you're equally liable for it.
Okay, sir. Thank you, sir.
Sir, there is one question on the chat box asked
Sure.
by Dr. Anusia. She says, can you share some insights about misuse of digital signature?
Misuse of digital signatures. I haven't, the digital signature misuse generally, what we have seen so far, I mean, my own personal experience has been issues like when you have to digitally sign something and you sometimes just place it in a common place. For example, these days the directors, when they have to sign the any minutes of the meetings that are held, and it has to be digitally uploaded, that he himself does not do. He actually sort of delegate that responsibility to either his chartered accountant or someone within his office who is actually using his digital signatures. And those kind of misuse, because they are placed in the hands of someone else and who may use that digital signature, we have come across. But I'm not sure if that is what is being asked me. I mean, or is there other ways that they're thinking that the digital signatures can be misused? So I think the question needs a bit more refinement, but yes, those kind of misuse we have seen of digital signatures, where someone has handed over those digital signature files for someone else to use, but they have gone ahead and used it for a different purpose.
Sir, I would like to add to the reply.
Please.
Digital signatures are different from electronic signatures.
Yeah.
Electronic signatures are just the scanned versions of the signatures, while digital signatures are related to cryptography.
Correct.
So the attacks on digital signature would be like, say, man-in-the-middle attack, or say other cryptanalytic attacks. These are the attacks that could be made on the digital signature. Earlier in the IT Act, they had used by mistake the word digital signature, but when they came to know that it is related to cryptography, so in the IT Amendment Act 2008, they had replaced that with the electronic signature. So electronic signature is just the scanned version of your manual signature that is stored in a digital form, while digital signature is a sequence of bits, just 0 and 1 of say 128 or 256 or 512 digits. That is a digital signature. So misuse could be related to the cryptanalytic attacks, like say man-in-the-middle attack, etc. Thank you, sir.
Okay.
As the topic has been started with reference to the digital signature and the electronic signature, basically we came across with many versions, particularly many situations where electronic signatures are to be given. So what is the credibility of these kind of signatures on the various documents? Anybody can create such kind of a document along with by using the digital signature, by just simply copying and pasting it.
So I think there are, as the previous, I think the difference is here is that a scanned signature being pasted onto a document is different from a digital signature, which is provided by a certain, governmental agency, which provides you those digital signatures. And there is when you sign those digital signatures, there is an ID which comes in, which can be verified.
Yes, sir. But this doesn't happen every time. Most of the time, people use the electronic signature, what sir asked, that is a scan version of the manual signature.
I understand that. I think, but the better ones, most people have started to use services like DocuSign and services like the Adobe signatures, where again, even though you can sign it as as an electronic signature, I don't know if any of you have sort of used that service, where you can actually print your name, where you can sign by your finger there itself, draw your signatures, or you can put your initials. But that document ultimately creates an ID to identify that which was the IP from which the signature was generated, the IP of your computer, or and it stores it to be verified later on that whether it is correct or not. But you're right. If it was just an electronic signature where you are able to do it on the basis of you are just putting the scanned version of your signatures, it can be copied and pasted anywhere.
Okay.
Yeah,
And
but
what are
then transactions, those are not acceptable. So when I was giving you the example of Ministry of Corporate Affairs, where you have to file any document digitally and sign it, even in the COVID times when we have filed cases in the courts, we are required to digitally sign the documents and not on these the documents which were just scan, and though were initially accepted, but later on they stopped it. It had to be either DocuSign or through Adobe Sign service, or it has to be digitally signed only that were being accepted.
Sir, with reference to the formulation of the digital policy in the context of intellectual property right, what is the future? Basically, whether the program can be, whether the program can be considered as an intellectual property, can we receive the patent for the same? What is the idea? Means in coming future in India, what kind of digital policy will be formulated? Is there any movement with reference to that?
Actually, the word digital is very sort of broad, and it kind of in isolation it is very difficult to kind of define a policy around it. It always has to be contextual. So, for example, today, the patent law, for example, when it comes to the software, there is a lot more controversy around it in terms of whether the software should be granted patents or not, because there is the certain section in the Patent Act 3K excludes software patents from protection unless it is embedded in a hardware. Now that definition continues to evolve. And the recent thinking on that, in terms of when we talk about the policy, you could say, which is being shaped also by how the world is evolving, is the fact that every mechanical device today has some kind of a digital interface being added to it. Every machine that used to be run either in a mechanized manner through in any way that it was being run, there is a microchip that is being inserted in order to make the machine run more efficiently, to be able to perform better. So in that sense, I think what we are seeing is that the digital world will continue to evolve, and we will need to just be open, and the law will have to continue to also evolve with time, to be able to sort of protect the consumers in some way, to protect the businesses, and to still be forward looking, so that we are not being bureaucratic in our approach, that we are not sort of rising to adapt and adopt the new technologies.
Sir, with reference to the Industry 4.0, particularly when we talk about the blockchain technology,
right?
There are the contracts, there are the agreements, and based on the agreements, the players in the blockchain, the players in the supply chain are expected to share their data. So what is the status at India level, means at the national level, what is the status? Whether this technology will be available in the industries in the next coming 5 years? Means what is the status as on today at the national level?
At the moment, there is no real guidelines available, but I can see that the private players have already started to take their positions in those technologies. They have started to already implement this, within their systems to make their contracts secure, to be able to work in line with what the rest of the world is doing. And I think the government will have to give some sort of a recognition to it as times go. So there is no stated, documented policy at this stage.
Okay, sir. Is there any other question? If there are no questions, then we will close the question answers and we will move towards the summary. Okay, so fine. So now I request Gayatri madam to summarize the session, and after that I request Dr. Sahu from Reva Engineering College to give the closing remark. Now Gayatri madam, please. Gayatri, are you there?
Yes, sir. Good evening to one and all. Thank you, sir, for your brief on IP in Online Space and Information Technology Act. You introduced your session with the question, why digital world is growing fast? And you explained the reasons why people are depending on internet, in which you considered the current COVID situation too. You covered 4 topics in the session. The first one was about how and why sale of counterfeit goods on e-commerce works, and also discussed about online marketplace and how Amazon and Myntra works. During the presentation, you have stressed on legal provisions pertaining to e-commerce portal and also the sections and also on Section 79 of the IT Amendment Act 2008 and its exceptions. Sir also highlighted examples of T-Series, Shop Clues, and Reliance Industries. The second one was about software and movie piracy, wherein the evolution of piracy was introduced and also losses to the entertainment industry was discussed. The cases and legal action and issues related to them were covered. The third point was data piracy and data theft, wherein the data collection point sources, Section 43A, were brought to notice, along with data theft and impersonation, which was made clear to understand with a video. The fourth point was job scams in the online world, where online job scam was explained, followed by probable legal actions, which was cleared by an example of fake website. Thank you.
Thank you, Gayatri madam. Now I request Dr. Sahu from Reva Engineering College to give the closing remark.
Thank you,
Dr.
sir.
Sahu.
Yes, am I audible, sir?
Yes, sir, you are audible, sir.
Okay. Thank you, sir. Thank you for offering this session to me. Okay, we have come to the end of the third day of this online workshop. We had a wonderful session for the past 2 days, and today also we had a wonderful session by Advocate Ranjan Narula on the topic intellectual property right in digital world. He covered many things, we know that some of the things we are aware of and many things we are not aware of. Like I would like to point out one major thing, that is the counterfeit goods which are being sold in e-commerce or online. And another thing which is very, very important, that is the job scam. Many people, many innocent people, they are falling to the trap of this job scam. Thank you, sir.
Thank you.
Now I would like to thank the principal of SPC Mumbai, Dr. M.M. Murdi, and principal Reva Engineering College, Dr. B.K. Agrawal, coordinator of this online workshop, Dr. Santosh V. Rane sir, and Technical Coordinator of SPC Mumbai, Dr. Rahul Dahatoni sir, and Technical Coordinator of Riva Engineering College, Dr. R.P. Tiwari sir, and the whole organizing team to organize such a wonderful wonderful workshop in the online platform. And I know that all the applicants are getting benefited, and they will be benefited in the coming sessions also. Lastly, I would like to thank all the participants, because without the participant, this will not be a successful one. And I like the interactive section very much. Thank you, sir.
Thank you, Dr. Sahu. Thank you for your kind words. So I'm really thankful to Mr. Ranjan Narula for sparing his precious time and sharing his expert inputs on the domain. Sir, we will be organizing the entire workshop once more for the remaining participants. They are waiting for the same in the coming future. So we will be requesting you once again to deliver the session in the same pattern. Thank you so much for your all inputs. Thank you, sir. Bye.
Thank you. Thank you all. I enjoyed it as well.
Bye-bye.
Bye-bye.
We will close our today's session.